Does every contested divorce case generally go through a negotiation phase?
The short answer is yes, it should. There definitely are exceptions to that. The exceptions being if a client comes in and says, I know for a fact there's no possible way my spouse is going to agree to what I'm asking for. And let's say you file the case and you get in touch with the other side and then you say, yeah, your client's right. There's no possible way my client's going to agree to anything your client is proposing. Well, then you don't need to have negotiations under those circumstances. Then the only issue is you go in, you set a discovery schedule, you get the case set down for as expedited a trial as possible. And you just let the judge know, this is where my client is at, this is where the defendant is at. We're not seeing that there's any middle ground there at all. And at the end of the day, we need a judge to rule one way or the other. You know, as but one example, if wife says, I want sole custody, I'm never agreeing to joint custody, my spouse is crazy, there's no way anyone can twist my arm along those lines. And let's say the other side says, yeah, I want the same exact thing. I want sole custody because the other side is crazy and there's no way I'm going to agree to anything other than that. Well, I'm sure the judge will let the parties know, look, at the end of the day, I may make a ruling that's not going to please one of you. And so you may want to consider, you know, some level of negotiation. The other thing too is the judge, you know, and the attorneys will mention to the parties, look, taking a case to trial is very expensive for most people. Unless you're independently wealthy and have $100,000 or $200,000 burning a hole in your wallet, you know, it's probably advisable to consider negotiating the issues. But, you know, like I said, some cases, they are few and far between, but they come in and you just see right from the beginning, there's really no middle ground that's possible between these two parties, in which case the only thing that you do at that point is just march down the road to a trial. I in fact, I have a case pending right now that's exactly like that, where my client came in, she's alleging she's a domestic violence victim. The other side has mental illness issues. She made it crystal clear to me when she retained me, there is no way on God's green earth I am consenting to joint custody. I want sole custody. I want restricted visitation for the father, et cetera, et cetera. Well, you know, in that case, it would almost be a waste of my time to go to opposing counsel and say, would your client agree to all that? You know, I of course throw it into an email, but I wouldn't spend all that much time negotiating that case because I could expect what the answer would be from the other side. If they go to the lengths of hiring an attorney, it means they want, ample visitation at the very least, if not shared custody or joint custody. So in that instance, we didn't waste all that much time negotiating the issues, and we just went before the judge and said, Judge, here's where we're at. Here's mom's position. Here's dad's position. There doesn't appear to be a middle ground. Let's do what we got to do to get the home studies done, get the forensic psychological evaluation done, and let's get trial dates as soon as possible. And that's what we're doing in that case.